Good evening, everyone. Am I audible to all? Good evening, sir. With your permission, may I proceed with the session?
Yes, please, Navjot.
Thank you, sir. Good evening, everyone. I am Navjot Kaur, the host of today's session. I, on behalf of the whole team of Just Corpus, welcome you all to today's session on bail jurisprudence under special criminal legislation in India, balancing personal liberty and statutory rights. Before we delve into today's discussion, let me provide a brief introduction of Just Corpus and the eminent guest speaker of the day. Just Corpus is a body of legal professionals who have come together to bring various aspects and chains of law under a single umbrella. Just Corpus, an edtech platform set up in 2020, has a wide reach of 6 lakh clicks per month on an average basis on our website www.justcorpus.com. The inspiration was derived from the ever growing need for law students. Just Corpus has also incorporated an interdisciplinary journal and a multidisciplinary journal as its subsidiaries, named as the Just Corpus Law Journal and the International Journal of Law Research, Education and Social Sciences. Chambers of Abhinav Mishra, Advocates and Solicitors. Founded in 2018 by Abhinav Mishra, the Chambers has emerged as one of the eminent legal service providers for its diverse practice capabilities and caters to matters pan India. The Chambers assist its clients by way of handling litigations in courts and tribunals and also provides corporate advisory as well as legal consultancy services on matters pertaining to IBC, M&A, competition laws, restructuring of debt, white collar crimes, real estate laws, IPR, and arbitration proceedings. Also, the Chambers is involved in assisting startup companies across different sectors by providing them with legal advisory and consultancy services to ensure legal compliance. The Chambers has successfully dealt with many complex issues and have rendered legal opinions on laws specific to various industries. The Chamber has, in a brief span of practice, procured certain reportable judgments from the Honorable Supreme Court of India and Honorable High Courts of various jurisdictions. The Chamber also focuses upon promotion and development of legal education by organizing webinars under the banner of Indian legal traditions on different topics pertaining to law. At the Chambers, they are dedicated to provide committed, realistic and pragmatic advice to their clients and guide them at each and every stage of the proceedings. Now, turning our attention to today's focal point, we are privileged to have Mr. Priyanshu Singh as our esteemed guest speaker. Mr. Priyanshu Singh, Associate Scale 1, Chambers of Abhinav Mishra, Advocates and Solicitors, a graduate of 2024 from School of Law, UPES Dehradun. Priyanshu Singh began his journey with Chambers as an intern, where his dedication and grasp of legal intricacies quickly set him apart. Following a successful stint as a paralegal, he transitioned into the role of associate and is now an integral part of the core team. Known for his approachable nature, Mr. Singh has particular interest in arbitration, commercial law, sports law, and environment law, areas in which he continues to grow his knowledge in. Clients and colleagues alike values his affable nature, which makes him a reliable team member and an insightful contributor in high pressure situations. Sir's experience extends beyond company law into a broad spectrum of legal domains, including matters arising under the PMLA, Aviation Law, and IBC. His clarity of thought and precision in drafting has helped him consistently in delivering structured, persuasive legal writing that simplifies intricate issues into compelling legal narratives. Sir is an explorer at heart and he applies the same curiosity and enthusiasm to his legal practice. His love for conversation and storytelling often makes him the bridge between complex legal issues and client understanding. Sir continues to deepen his engagement with dispute resolution and commercial advisory and is steadily carving out a reputation for being both dependable and dynamic in his approach. So, with this introduction, let's give this floor to Sir. Sir, your mic is on mute.
I'm sorry. Thank you so much, Navjot, for such a warm welcome. Uh, Before I begin, I would just like to mention that the initiatives taken by Just Corpus, wherein they are engaging multiple people across the industry to deliver lectures and to ensure that legal education grows, is really impeccable. And it is something that needs to be done so as to ensure that the people that are in law schools or are just getting into the profession get a hang of what it is like. So I'm thankful for that, and I'm grateful for this opportunity and for having invited me. Okay. On that note, good evening, everybody. My name is Priyanshu Singh. The topic on which I will be giving my lecture today on is bail jurisprudence under the various special criminal legislations in India. Now, before we begin, the whole idea behind choosing this topic is that if we are to consider bail, the whole concept of bail as a whole, we get to know that bail per se is not something that is there's a thumb rule by which it can be abided by. So there are obviously different circumstances under which a bail is granted or denied. Now, while there are ordinary legislation, which is at the current instance the BNSS 2023, which was the erstwhile CRPC as well, there are also certain specific criminal legislations under which what the legislation has done is to introduce certain very offense or statute specific conditions under which bail will be granted. Now, that is what we will be exploring today. While doing so, what we'll also keep in mind is the factum that Article 21 is something that is enshrined to every individual as per the Constitution of India. Now, when considering factors like bail, one of the most significant aspects or one of the most important things that the honorable courts are, in a way, I would not use the term burdened, but in any way, something that they have to strike a correct balance. So it is only upon their complete wisdom that they are able to come up with a proper, say, adjudication of this. On that note, we begin. So, if I was to very roughly put it and ask what to the crowd or to everybody that's watching this, what, according to you, is the meaning of bail? I will just ask my colleague to share with me the YouTube link so I can see your responses here. It can be layman, it can be anything that you understand by the term bail. Okay. So if I was to put it as per what the statute provides for it, now Section 2B of the BNSS defines bail as bail means release of a person accused of or suspected of commission of an offense from the custody of law upon certain conditions imposed by an officer or court on execution by such person of a bond or a bail bond. Now, when we read this definition, while we understand what the whole terminology of bail means, what I would like for you to pay emphasis upon is this very terminology that is stated here, that's upon imposition of certain conditions. Why I say this is important is because now what we need to understand is that bail is not something that is unconditional, right? When the honorable courts are considering any application for bail, there will obviously be certain conditions, there will be certain grounds that they take into consideration, and there will always be certain conditions that they impose. Now, as you can also see that it's mentioned in the slide, it is not something that will completely give any person being enlarged on bail a complete liberty. So, see, you can see this aspect that I mentioned when I began, right? It's about striking a correct balance between ensuring that somebody's Article 21 is not violated, but at the same time, there are reasonable restrictions, or there are certain conditions that are imposed that are warranted in any case. Because, I mean, releasing an individual without any specific conditions or unconditionally would go against the whole virtue of any criminal proceeding having been begun in against them, or for that matter would even prejudice the whole trial or the entire proceedings. Now, if you take into consideration why are bail conditions imposed, see, like I mentioned, right, this is not something that can be unconditional from the end of the honorable courts as well. So if per se we were to, now again, before we get into the conditions, see, whatever the conditions are to be imposed will again depend upon a case to case basis. I would not say that there is any particular thumb rule or there is a proper statute that mentions that these conditions will have to be imposed upon a person seeking bail. It is completely upon the judicial discretion of the honorable courts, whatever they are to eventually decide. But if you were to somehow narrow it down to a few factors or a few conditions or a few, yeah, let's say factors that are taken into consideration by the honorable courts, we'll begin with the first one, which says to ensure that the accused person appears in court. Now, why is this important? See, the whole purpose behind somebody being in judicial custody, or for that matter, being not enlarged on bail upon the allegation of any offense, is that he or she may be required for investigation. His or her presence will be is absolutely necessary so that the trial is conducted in a smooth manner. Next being to prevent the accused from absconding. Now, this is a very important aspect. I say so because what we have noticed over our practice also, and I think this is something that is very prevalent also in a lot of cases that we see, is that even upon bail applications being preferred, this is one very specific point on which the prosecution's case rests, stating why a bail should not be granted to an individual. Because you see, if an individual who is in the judicial custody is to be enlarged on bail, and then he's somebody that runs the risk of leaving the country or completely disappearing or just becomes untraceable for that matter, right? So the whole purpose of an investigation or for the trial, it would serve no purpose then. Because then now the whole trial process or the whole investigation is stalled. So therefore, this is something that generally weighs with the honorable courts when considering applications for bail. To protect evidence and witnesses. Now, see, this is also a case where if you if there is an offense against somebody that has deep roots in the society, that it is about somebody that is highly influential for that matter. Now, it's very easy for them that when they are enlarged on bail, they can very easily use their influence, the power that they have, the endless amount of money, let's say, that they have, and then they can very easily either influence the witness, they can threaten them. This is a very general rule that, I mean, we see a lot happening, and this is again one of the factors that the honorable courts do consider whether when considering an application for bail or not. The fourth being to maintain public order and fair investigation. Now, with this, when I say bail, when I say public order, so you see, if you are somebody, I mean, if not you are somebody, if there is an accused who is, say, an alleged accused in a very heinous crime, or is somebody that has committed a crime because of which there is great national unrest. Now, you see, if you are to release him on bail, you realize the ramifications that it may have. In addition to him or her completely affecting the fair investigation of the process. Now, while our lecture is going to be a little restricted to the aspect of bail when it comes to special legislations, it just becomes important that we all know that bail per se in the Indian perspective can be more or less divided into two umbrella terms. One is anticipatory bail, or what we also call as pre-arrest bail. It is generally pleaded for जब किसी को लगता है कि उस वो अरेस्ट होने वाला है, और if he apprehends that because there may be a certain case filed against him and the police may require him to be arrested. That is one case. And the second is bail, that is regular bail. Now, there is a division in this as well. One is for bailable offenses, the other is for non bailable offenses. Now, I told you about what are the conditions that may be that weigh with the honorable courts when deciding an application for bail. Now let's look at it from a perspective. आप ये सोचिए कि आप जजेस बैठे हैं ऑनरेबल सुप्रीम कोर्ट में या हाई कोर्ट में, और फॉर दैट मैटर इन एनी कोर्ट. अब आपके लिए जब कोई एक एप्लीकेशन आता है आपके पास बेल एप्लीकेशन का, आप अपने जुडिशियल माइंड का यूटिलाइजेशन करते हुए क्या ऐसे फैक्टर्स क्या होंगे जो आप कंसिडर करेंगे? आई मीन अल्टीमेटली यस, फैक्ट्स टू फैक्ट्स केसेस में ये इट ऑब्वियसली डिपेंड्स, but there are certain things that in any case will have to be considered by the honorable courts. Let's look at what they are. The first being the nature and gravity of the offense. Now, what do we understand by nature and gravity of the offense? I mean, if I would actually love and appreciate if I could get some answers in the chat box. It can be anything. You can give me layman language terms. You can give me whatever you understand by these terms. I will just take a couple of seconds to peruse through your comments if you are giving them to me, so I am able to know that you're all following. Okay, somebody, I can see one response though. Somebody says seriousness of the offense, somebody means gravity of the offense. You are correct. I mean, that is exactly what's also mentioned in the slide, but how heinous the crime is, yes, Urvaj, right? So, yes, it's more or less whatever you people have mentioned. It's in fact exactly that, if I am to put it in simpler words. Now, you understand that अगर आप बैठे हैं सुप्रीम कोर्ट में या हाई कोर्ट में और आपको आपके पास एक एप्लीकेशन आई है बेल के लिए, and say that offense is about a murder of a family, or is a very heinous crime, तो आप इस चीज को वे जरूर करेंगे एज इन टू कंसिडर वेदर और नॉट इट इज अ फिट केस टू ग्रांट दिस पर्सन बेल और नॉट. आप ऑर्डिनरीली सोचिए, अगर आप अपना जुडिशियल माइंड अप्लाई कर रहे हैं एंड आपको एक बेल एप्लीकेशन कंसिडर करना है एक ऐसे इंडिविजुअल का दैट हैज कमिटेड अ ग्रेव ऑफेंस ऑफ से मर्डर ऑफ अ कपल ऑफ पीपल, और upon being put into judicial custody, he approaches you within a couple of days stating that whatever XYZ reason he may give, you will not really be inclined to grant him bail until unless there is something that is very, that, I would say, reach to affect your conscience. But हाँ, nature अगर हम और gravity की बात करें तो it in essence means what is the gravity or what is the magnitude of an offense that is being pleaded for, a bail application is being pleaded against. नेक्स्ट बिकम्स अ मेडिकल कंडीशन और द एज ऑफ द अक्यूज्ड. अब आप इस बात को समझिए, आप एक इंसान, आप जज हैं, आपके पास एक एप्लीकेशन आई है बेल के लिए, उसमें उनका बेल सीक करने का ग्राउंड बहुत सिंपल है कि मनोज, आई एम 68-year-old मैन, आई हैव अ वेरी सीरियस इलनेस, और मुझे इस चीज के लिए मेडिकल मेडिकल ग्राउंड्स पे मुझे बेल चाहिए. तो आप ये भी समझिए कि आई मीन द लॉ फंक्शंस इन सच अ वे दैट if there is an investigation ongoing against him, it is innocent until proven guilty, or in any case medical grounds or very extreme circumstances जिसके लिए आप बेल मांगते हैं उसके लिए the courts will be inclined to grant you. अब लेकिन provided there are certain, obviously, conditions being imposed on them, that that the person so being enlarged on bail is not allowed to leave a particular territory. He or she will have to report the police. But there is also a very important catch here. You see, it will become very easy for anybody to just claim bail on medical grounds. So is in cases में what the honorable courts very strictly take into consideration is submission of appropriate documents. अब ये हो सकता है a doctor's opinion stating that you require medical treatment etc xyz whatever the case may be. फिर नेक्स्ट है कंडक्ट एंड कोऑपरेशन ड्यूरिंग इन्वेस्टिगेशन. अब ये इंपॉर्टेंट क्यों है? अब ऐसे समझिए, यू आर somebody that has approached the honorable court stating you want bail, or you are saying that you will abide by all the conditions that are imposed. आप कहीं नहीं जाएंगे, आप कोऑपरेट करेंगे, लेकिन जब आप कस्टडी में थे and you have failed to cooperate, you are not speaking up, or for that matter even if you are outside and there had been in the past आपको समन्स आते थे अपीयर होने के लिए, आप नहीं अपीयर होते हैं, तो this reflects very poorly upon your conduct, and that is something that will ideally not weigh in your favor. Somebody's response has come in the chat box कि सर मेडिकल सर्टिफिकेट तो फेक भी बना सकते हैं. बिल्कुल बना सकते हैं, बट आई मीन ये तो फिर जुडिशियल स्क्रूटनी की बात हो जाएगी ना. I mean, if anybody wants to give you a fake medical prescription to be put before any honorable court, I mean, that is, वो बहुत, it's a very big risk that person would be taking then, at least in my opinion. फिर next है likelihood of tampering with evidence or influencing witnesses. This is something that I think we've already covered previously. You are somebody that is an influential person. आपके पास बहुत पैसा है, आप किसी को पैसा खिला के बोल सकते हैं कि बस ये लो पैसे, अब मेरे अगेंस्ट आप कुछ नहीं बोलोगे. आप या फिर थ्रेट कर देते हो, किसी को थ्रेटन कर देते हो, किसी विटनेस को कि एक्स वाई जी चीजें कर दूंगा मैं तुम्हारे साथ अगर तुमने मेरे अगेंस्ट कुछ भी बोला तो. नेक्स्ट बिकम्स पीरियड ऑफ इनकार्सरेशन. अब कैन आई गेट any response with regards to what you understand by the term period of incarceration? Somebody's response has come, what if he runs away? I mean, we will ideally be taking questions in the end, but I think such questions I would just like to address here and there. Now see, the whole point becomes that if you go back to one of the previous slides that we had addressed, कोर्ट्स जो है वो बहुत स्पेसिफिक कंडीशंस के साथ बेल इम्पोज करते हैं. इन सच केसेस क्या होता है, वो कभी कभी योर पासपोर्ट्स आर impounded, you are given very strict instructions to appear before the concerned police station within a couple of days, या फिर there are very strict conditions. I mean, see, obviously the honorable courts would take all these factors into consideration before they give you bail. तो it's not a very uncommon practice कि courts कह दें कि आप अपना पासपोर्ट जो है उसको सबमिट करेंगे, आप रेगुलरली अपीयर होंगे किसी पुलिस स्टेशन में, अपना अपीयरेंस मार्क करेंगे, यू विल नॉट लीव द सिटी. सो दीज आर कंडीशंस दैट आर देयर. आई हैव अ रिस्पॉन्स दैट सेज अगर कोई अक्यूज ट्रायल के दौरान जेल में रहता है तो उसने जो टाइम कस्टडी में स्पेंड किया है उसे पीरियड ऑफ इनकार्सरेशन कहते हैं. वंडरफुल. दिस इज व्हाट द पीरियड ऑफ इनकार्सरेशन मींस. आप बेल लगाने गए हैं कोर्ट में, आपका एक ग्राउंड ये है कि आई हैड बीन अरेस्टेड ऑन द 1 जनवरी 2025. आज जो है 15 फरवरी 2026 हो गई है मेलोड्स. आई हैव बीन इन जेल फॉर द पास्ट 1 year 2 months. ट्रायल में कुछ हो नहीं रहा है, इन्वेस्टिगेशन कंप्लीट हो चुकी है, मेरा कोई यूटिलाइजेशन है नहीं जुडिशियल कस्टडी में, तो मुझे बेल दे दी जाए. दिस इज वन फैक्टर दैट विल बी कंसिडर्ड. अगर बहुत प्रोलॉन्ग पीरियड ऑफ टाइम के लिए आप जेल में हैं एंड द ट्रायल इज नॉट एडवांसिंग or is at a stage where it has come to a standstill and there have been no further developments, and you are able to make a case to show why you are not required in judicial custody. So this will also weigh well in your favor when seeking any application for bail. Similarly, all the factors that I mentioned to you, this was also dealt by the Honorable Supreme Court in the matter of Prahlad Singh Bharti versus State and City of Delhi. It is a 2001 case. Isme bhi more or less the Honorable Supreme Court has given down certain guiding principles to say what are the things that will be considered when seeking any bail. See, most of these things are something we had covered. Nature and seriousness of the accusation, it becomes the same thing कि उसने क्या offense किया है, किस gravity में किया है, उसका role क्या था, nature of supporting material placed on record. इससे बहुत simple चीज़ ये आप समझिए कि what if there is any FIR or charge sheet that is filed against you for the commission of XYZ offenses. उस offense से connection में what are the material that has been placed on record to show कि नहीं आप ही नहीं किया ये offense. Severity of punishment upon conviction. This means say you have committed an offense जिसमें जो the maximum period of imprisonment जो आपको मिल सकता है वो 7 से 10 साल है, और अगर आप उसमें आके कहते हैं कोर्ट में कि आई हैव अंडरगॉन 2 months of imprisonment, so therefore I want bail, see obviously that will not be something that will go in your favor, right? क्योंकि 10 साल का कहाँ imprisonment आप 2 महीने में आके बोल रहे हो कि हो गया मेरा. Possibility of securing presence at trial, likelihood of tampering with witnesses or evidence, larger interests of society and the state. Now, all these three factors are something we have already covered. I have explained to you ये सारी चीजें क्यों consider की जाती है. अब यहाँ पे what is of significance for us to consider is the factor that reasonable grounds for believing is the terminology that has been used. And what do we understand by that? If I was to give you a very small essence of it, it simply means कि if you are somebody that is undergoing trial, or आपका trial is yet to commence or is yet to conclude, or investigation is also ongoing for that matter, and you come saying to the honorable higher courts or the appellate courts that you want bail for XYZ reasons. अब देखिए, the honorable appellate courts will not start to reappreciate evidence or to appreciate evidence from the beginning, given the fact that अभी trial तो होना बाकी है आपका. So that is something that is eventually adjudicated upon during the time of trial. So when the honorable courts consider any application for bail, it is about forming a prima facie opinion as to whether or not a case is made out against you. The moment it is, अब ये मान लीजिए कि the court is now of the opinion that yes, you have committed a particular offense, then we proceed with other such grounds which the honorable courts may or may not consider. See this now, this is a small comparison between bail in bailable offenses and bail in non-bailable offenses. It is a given rule that procuring bail in offenses that are non-bailable in nature is extremely difficult. आपने बहुत ही बड़ा हीनियस क्राइम किया है तो इस इन केसेस में आपको बहुत रेगुलरली बेल नहीं मिलेगी. In such cases also there are exceptions obviously that was provided in the statute itself, being if you are below 16 years of age, you are a woman, you are somebody that is sick or not keeping well. Whereas in the other case, bailable offenses में even if it is comparatively say easier to get a bail, आपको एक पर्टिकुलर अमाउंट के बेल बॉन्ड फर्निश करने पे आपको बेल मिल भी जा रहा है. लेकिन अभी आप में से किसी का एक क्वेश्चन या क्वेरी था कि व्हाट हैपेंस इफ दे रन अवे, टू व्हिच आई हैड रिस्पोंडेड कि कंडीशंस इंपोज होती हैं, लेकिन उसके बाद भी व्हाट हैपेंस इफ दे स्टिल रन अवे. सो देयर आर प्रोविजंस दैट वेरी स्पेसिफिकली स्टेट कि in such cases what, see now we'll not look at this from the perspective of say specific criminal legislation. हम इसको बहुत simple terms में the existing criminal law के basis पे देखते हैं. BNSS में say you run away but eventually you are caught and you come back and after a period of time you look to get bail. आपका तो हिस्ट्री है ना एज एन एब्सकॉन्डर, अब तो आपको फिर मिलने का स्कोप ही नहीं बचा. Next. Now, so I did mention to you ki what happens in cases when you have done a very heinous crime and your imprisonment is for say 7 years, 10 years. In such cases also, even if upon proper perusal and of a opinion courts को लगता है कि नहीं आपको bail मिल सकती है for a limited period of time and on imposition of very strict conditions, they may grant you a bail and impose very particular conditions upon you जहाँ पे आपको एक bail bond भी furnish करना होता है. The amount is determined by the court. And you are also given strict directions कि you will not try to contact the witness, you will not try to influence them, you will not abscond XYZ. अब इन केसेस में the honorable courts also have discretion now कि वो कोई भी other condition आप पे impose कर सकते हैं. Now, if we are to consider what are the term any other condition, right? Any other condition sounds like a very very large term. तो बहुत बड़ा ambit बढ़ जाता है. But to cope with this, Honorable Supreme Court ने in the case of Sumit Mehta versus State and City of Delhi, citation is here, is there in the PPT. Isme what the Honorable Supreme Court has attempted to do is that when these other conditions जो हम कह रहे हैं, हमने जो ऊपर पढ़ा है, that any other condition, इसमें आप ये देखिए कि there will be three aspects of it, or there will be three basic thumb rules that will be considered under this whole ambit of any other condition, right? The first of all being that this condition needs to be reasonable. Second, it must be justified by the facts of the case. अब आप देखिए that in case your conditions are imposed that you have committed, say, a fraud or a crime of around 3 lakh rupees, you have cheated somebody and you want to seek, I mean, this is not per se will not come under this ambit of 7+ years, but I'm just giving you a very very general example in the most simplest of words possible. And the honorable court imposes a condition upon you कि आप 10 लाख का bail bond दे दो. You see, I mean, the act that you have committed and the offense that is alleged against you, uske basis pe these additional conditions may be imposed upon you, so they cannot be inconsistent with each other. Now now this, to say, is the core aspect of our lecture. Because if we, like, if you may remember, for anybody that has been watching since the beginning, the whole idea or the whole डिफिकल्टी भी कह सकते हैं आप इस चीज को, या फिर होल एस्पेक्ट बिहाइंड बेल इज वेरी सिंपल. आपको इतना इंश्योर करना रहता है दैट द पर्सन हु इज सीकिंग बेल, देयर आर्टिकल 21 इज नॉट बीइंग वायलेटेड. अब आर्टिकल 21 इज ऑब्वियसली अ कॉन्स्टिट्यूशनल राइट, आप किसी को डिप्राइव नहीं कर सकते उसके लाइफ और पर्सनल लिबर्टी से. एंड obviously since it's given in the Constitution of India, it becomes, to say, all encompassing, or it cannot be kept in abeyance. So which is why what the honorable courts are often burdened with is to find a right balance between ensuring कि आपका article 21 एक हाथ में है, and in the next, and if you have to keep a weightage, right, it is to ensure that neither one of them, exceeds the other. Both of them are very particularly balanced in such in this aspect. Again, we'll find a lot of cases wherein the whole aspect of article 21 being important. आर्टिकल 21 को क्यों आप वायलेट नहीं कर सकते हो, आप आर्टिकल 21 को बिना कंसिडरेशन में लिए क्यों कोई एक ऑर्डर नहीं पास कर सकते हो, या फिर कोई एक डिटर्मिनेशन क्यों नहीं कर सकते हो. दीज आर ऑल फैक्टर्स यू विल फाइंड इन अ लॉट ऑफ केस लॉज. ठीक है. बट if I am to put one case law here, there is this case of the Honorable Supreme Court, as you can also see in the slide in front of you. It is Sanjay Khanna versus CBI. This is an Honorable Supreme Court's judgment from 2012. It, अब इसमें what happens is that, you see, if you are somebody that is in judicial custody, you cannot remain in that custody for as long as the trial goes on. अब आप एक बात समझिए कि हमारे कंट्री में ट्रायल्स जो चलते हैं ट्रायल कोर्ट में, फॉर लॉट ऑफ ऑफेंसेस, अगर आप ग्रीवियस और ग्रेव ऑफेंसेस के लिए सोचे जिसमें मल्टीपल पीपल आर इन्वॉल्व, इंटरनेशनल पीपल है, कंपनीज हैं, लेयरिंग ऑफ फंड्स हो रखे हैं, मल्टीपल प्लेसेस में डिफरेंट डिफरेंट नेचर ऑफ ऑफेंसेस ओरिजिनेट हुए हैं आपके एक पर्टिकुलर एक्ट से, तो दैट इज इन एनी केस अ लोडेड ऑफेंस, दैट विल टेक टाइम. But even offenses of, say, like murder, you know, they also will take you time, and it's not very odd if a trial can go on for 10 years, 12 years, 15 years, जो भी है. So in such a case, you cannot expect somebody that is an alleged accused in such cases to remain in judicial custody, right? कब तक आप on the guise कि नहीं नहीं, we there is an apprehension that he is the prime accused, till how long can you keep somebody in jail? So which is why the Honorable Supreme Court very clearly stated in this particular judgment that Article 21 must be weighed particularly, and merely just keeping somebody, and it must be kept in mind that the whole idea behind Article 21 is that speedy trial is ensured. Next. Stopping. Okay. Now, before I proceed with the slides further, could I just take a few responses on the aspect of when I say special criminal legislations, क्या है ये special criminal legislations हमारे country में? If anybody, I could, you can give me any, what is your understanding of it, you can write it down in the comment section. I have it open in front of me, so I'll be able to see your responses. The responses so far I have are POXO. See, now POXO, although yes, it is in a way a special criminal legislation, but then it is also governed by the principles of BNSS when it comes to bail. Somebody said BNS. It is the existing criminal legislation in our country. These are the general BNSS, BNS, everything that you mentioned. Anything beyond that, those, when I say special criminal legislations, मैं बस ये बता दूं, what I try to mean, what I'm implying here is that एक पर्टिकुलर नेचर का ऑफेंस के लिए अगर आप देखिए बीएनएसएस और आईपीसी जो है उनमें बहुत सारे ऑफेंसेस कवर होते हैं दैट आर क्रिमिनल इन नेचर, दैट इज फेयर. बट अगर आप सोचिए देर आर पर्टिकुलर लेजिस्लेशंस इन आवर कंट्री दैट हैव बीन इनैक्टेड फॉर अ वेरी स्पेसिफिक पर्पस. एक पर्टिकुलर ऑफेंस या फिर एक पर्टिकुलर नेचर का ऑफेंस को कवर करने के लिए है हमारे कंट्री में कुछ ऑफेंस, कुछ एक्ट्स ऐसे. See somebody, yes, now I'm getting answers. Somebody has mentioned PMLA, Isha Jain. Akshat Sharma mentions NDPS. Somebody says labor law. Okay. Yes, Akshat, that's correct. NDPS when there is a commercial quantity of narcotics involved. Perfect. Pankaj, you are correct as well. TADA was also one such act where it was enacted with the purpose of curbing terrorism in the country. It has now been repealed for a very long time now. There is another law that currently deals with the aspect of terrorism in our country. We'll get to that when we reach the slide. Hmm. Right. Okay. So I think we'll begin with the Prevention of Money Laundering Act. See, this is one of the first responses I think I got in the chat as well. तो PMLA in short होता क्या है? अगर हम if we are to go by the name of it itself, I think we get an idea as to what this act basically looks to curb, right? It is in essence an act that was enacted by the legislature to ensure that offenses pertaining to money laundering, siphoning of funds, layering of funds, these are all more or less aspects that fall under the ambit of money laundering itself. They were, there was somebody says that Indian Contract Act is a specific criminal legislation. I don't think so, man. I mean, contract, ठीक है. So PMLA is one such act that we will also be covering here. अब इसमें who is the investigating agency? As you can see, it is the Directorate of Enforcement, जिसको in short हम ED भी कहते हैं. अब if we are to consider the rigors of bail in offenses under the PMLA, there is a very specific statute now. The act very specifically states in section 45 कि if you are somebody that is alleged to have committed an offense under the Prevention of Money Laundering Act 2002 and you are seeking a bail, there are two conditions that you will need to fulfill. See, the first condition is obviously in a way the whole aspect of audio alteram partem, right? That the public prosecutor has been given an opportunity to oppose the application of such a release. That is fair. But the next point is where the whole judicial discussion or the whole ambit of case laws or precedents that we see in our country exist out of. The first point obviously being that the court is satisfied that there are reasonable grounds. Again, we need to emphasize more upon this aspect that the statute has very specifically used the term reasonable grounds. उन्होंने ये नहीं कहा है कि is completely satisfied. Because see, obviously आप एक बात समझिए, अगर आपका ट्रायल ongoing है, या if there is an investigation ongoing and your trial is not even commenced, and you first approach the learned trial court, right, stating कि you need bail. अब इन cases में the terminology here used is reasonable grounds. अब ये reasonable grounds क्या होते हैं ये हम देखेंगे बाद में. I will explain it to you as well. But if I am to restrict myself to first this slide, see, it is never, the terminology used here is not upon its complete satisfaction. You get it? अब कंप्लीट सेटिस्फैक्शन नहीं होने के दो कारण भी हैं, सो टू से. एक अगर हम सोचें, से आप एक बात समझिए, यू आर समबडी दैट इज say a special judge or you are sitting in the district and session judge and this is a trial that is come to your court. ठीक है, आपने एक अक्यूज का बेल रिजेक्ट किया, वो उसे अग्रीव्ड होता है, वो जाता है ऑनरेबल हाई कोर्ट. हाई कोर्ट में जो जजेस, ऑनरेबल जजेस बैठते हैं, उन्होंने अपने अपने ऑर्डर में लिख दिया, अपॉन ड्यू कंसिडरेशन वी आर ऑफ द ओपिनियन एंड वी हैव satisfied ourselves in length that there is no case against the accused, so he is therefore enlarged on bail. Will it not weigh upon you when you are ultimately doing, adjudicating the trial? ये आपके दिमाग में रह जाएगा. So which is why even the statute ensures, and that is something even the honorable courts ensure, that reasonable grounds is the only thing that is considered. The next aspect being that he or she, whoever is, for the offense that he or she has committed, is not likely to commit any other of the same offense if on bail. Now this is important. You understand, right? Why this satisfaction is required from the honorable courts to be recorded in their particular orders. Because see, you are somebody that has allegedly committed money laundering. आपने बहुत लाखों करोड़ों का स्कैम की फ्रॉड किया है, और अपने अनड्यू मेथड से आपने उसको प्रोक्योर किया है, प्रोसीड्स ऑफ क्राइम, अब बहुत अच्छे से रह रहे हैं, you're utilizing that money very well. Now you are somebody that has been, against whom proceedings have been initiated. You come to the court saying कि नहीं मुझे bail दे दीजिए. अब if the second condition is not there, you realize the repercussion that it may have. You'll go out on bail, you'll do the same thing again. So which is why the statute was very particular when it came to introduce the aspect of what are the conditions that will be required when considering an application for bail. In such a case, both these conditions that I mentioned. Here again, there are certain, to say, exceptions, which is again in line with the provisions of CRPC as well, or the existing BNSS. Next. Now, if I am to pinpoint or speak about two very particular case laws in this matter, right? So before doing that, I would want to ask you a question as to how many of us know what is the meaning of parity when it comes to seeking bail. Parity का मतलब क्या होता है? In the meanwhile, you answer that. I will also try and go through a few of your other questions if you have. So, any explanation as to what parity means according to you? The term parity, even if not in terms of bail, but parity in general क्या mean करता है? Don't seem to be getting any responses. Equality. Yashvi says equality. ठीक है. So more or less the responses that I seem to be getting is people stating equality. ठीक है, you are correct. But now Lucky Sisodia says equality of treatment. Absolutely correct. Similarly, if we are to consider it in the aspect of bail, parity अब कब arise होता है? A case of parity अगर हम देखें, parity in such cases will occur जब आपने कोर्ट को अप्रोच किया है, राइट? आप ग्राउंड्स दे सकते हैं, एक्स वाई जी, योर रोल इज नॉट मच, आपको बहुत लंबे टाइम से आप जेल में हैं, एक्स वाई जी. पैरिटी का ग्राउंड अब यू कैन प्लीड व्हेन से आपने एक ऑफेंस कमिट किया है मनी लॉन्ड्रिंग का, आपके साथ तीन लोग, आपके दोस्त भी इन्वॉल्व थे, आपने चारों ने मिलकर बहुत अच्छे से मनी लॉन्ड्रिंग कर दिया. अब होता क्या है, आपने अप्रोच, आपके तीन दोस्तों ने अप्रोच तो कर लिया कोर्ट को, उसमें उन्हें मिल गई बेल, ठीक है, आप रह गए कस्टडी में अकेले. नाउ देन यू अप्रोच द ऑनरेबल कोर्ट स्टेटिंग कि अरे मैं भी तो, मेरा भी तो रोल सेम ही था, आपने बाकी तीन को दे दिया, मुझे भी दे दो. That is, in the most simplest of terms, what the whole principle of parity means. It is the aspect of seeking an equal footing with other co-accused persons, or stating that since they have been enlarged on bail for an offense allegedly have been done by them, and I am also one of the co-accused persons, hence मुझे भी parity दे दीजिए and grant me bail as well. अब देखो, अगर ये केस रहता तो बहुत इजी हो जाता हर किसी के लिए बेल लेना, नहीं? तो विच इज वाई थ्रू precedents we often come up with a solution to everything. तो सिमिलरली ऑनरेबल सुप्रीम कोर्ट ने तरुण कुमार वर्सेस ईडी के मैटर में, दिस इज 2023 जजमेंट, दे वेरी स्पेसिफिकली हेल्ड कि आप बस कोर्ट में आके बस ये नहीं कह सकते कि जस्ट बिकॉज समबडी एल्स दैट इज एन को अक्यूज्ड विथ योर कोर्ट बेल तो आपको भी मिल जाना चाहिए. यू हैव टू ऑल्सो प्लीड और शो कि आपका रोल कैसे सिमिलर है उन अदर को अक्यूज से. बिकॉज यू अंडरस्टैंड, राइट? आपने एक मनी लॉन्ड्रिंग का फुल, बहुत वेल स्ट्रैटेजिकली प्लान, आपने मनी लॉन्ड्रिंग कर ली, बहुत करोड़ों रुपए कमा लिया आपने, और उसमें आपने अपने 3 दोस्तों का हेल्प किया, जिसने क्या किया, एक ने गाड़ी चलाया, एक ने आपके साथ से जहां से आपको प्रोसीड्स ऑफ क्राइम जनरेट होते हैं वो आपसे, उसने जाके वो सूटकेस उठा के लाया. अब आप 4 फंस गए. बाकी 3 को मिल गया, क्यों? क्योंकि उनका रोल ही नहीं था ज्यादा. अब आप जाके ये नहीं कह सकते ना कि मुझे भी दे दो इस ग्राउंड पे ही बस. विच इज वाई द ऑनरेबल सुप्रीम कोर्ट वेरी स्पेसिफिकली स्टेटेड दैट the role of the accused must be weighed very particularly. You cannot be somebody that has orchestrated the entire operation. You cannot be somebody that has commenced, that has planned, that has plotted the entire operation, and because of you, you had engaged 3 other people with you to assist. See, PMLA there is this whole aspect that even if you are somebody that has aided or assisted in the process of money laundering, आप फिर भी हो liable for the offense of money laundering. लेकिन बेल सीक करते समय आप ये सेम ग्राउंड पे नहीं प्लीड कर सकते, सिंपली स्टेटिंग कि दीज अदर को अक्यूज्ड हैव आल्सो गॉट, क्योंकि आपका रोल ज्यादा है, आपको बेल नहीं मिलेगी. नेक्स्ट, अगर हम एस्पेक्ट कंसिडर करते हैं, प्रोलॉन्गेशन ऑफ ट्रायल. अब दिस इज व्हाट आई वुड से द प्रॉपर एंड इन एसेंस अपने आर्टिकल 21 को इन्वोक करना व्हेन अप्रोचिंग द सुप्रीम कोर्ट और द हाई कोर्ट और एनी कोर्ट सीकिंग बेल. देखिए, इसका कॉन्सेप्ट बहुत सिंपल है. आप जाके कोर्ट को बताइए कि आप अरेस्ट हुए थे 1 जनवरी 2020 को, आप अभी तक जेल में हैं. और फिर वो पूछेंगे आपसे कि ट्रायल का स्टेटस क्या है. आपसे नहीं पूछेंगे भी तो प्रोसिक्यूशन से पूछेंगे कि ट्रायल का स्टेटस क्या है. एंड बेसिस दैट द ऑनरेबल कोर्ट विल इवेंचुअली फॉर्म एन ओपिनियन दैट नहीं, इस केस में इट इज़ नॉट लाइकली कि ट्रायल बहुत जल्दी कंक्लूड होगा, या फिर अभी इन्वेस्टिगेशन कंप्लीट हो चुकी है, आपका कोई रिक्वायरमेंट नहीं है, एक्स वाई सी. देखिए, इट विल अगेन, like has been the constant point that I've mentioned, this varies from case to case, right? तो इसमें there is no particular thumb rule stating कि ये चीज होंगी वो नहीं होगा, ये होगा वो नहीं होगा. सो देखिए, केस टू केस बेसिस पे ये जो केस लॉ है, मनीष सिसोदिया वर्सेस ईडी का केस, इस केस में प्रोलॉन्गेशन ऑफ ट्रायल के बेसिस पे ऑनरेबल सुप्रीम कोर्ट ने ग्रांट कर दिया था बेल प्राइम अक्यूज को. लेकिन उसमें एक बहुत इंपॉर्टेंट फैक्टर ये था कि जो ट्रायल कोर्ट के रिकॉर्ड्स थे उसमें देवर अप्रॉक्सीमेटली अराउंड 490 विटनेसेस. जो इसमें पेपर बुक रिकॉर्ड था, इसमें इट रैन इन थाउजेंड्स एंड लैक्स ऑफ पेजेस, और ट्रायल एज सच कुछ कमेंट्स भी नहीं हुआ था. सो विच इज वाई सी, लाइक आई मेंशन, केस टू केस बेसिस का फैक्टर रहता है. इन सच अ केस देवर द प्राइम अक्यूज वाज ग्रांटेड बेल. इन अ सब्सिक्वेंट केस से अगर कुछ ऐसा हुआ जहां पे इन्वेस्टिगेशन हैज जस्ट कंक्लूडेड, ट्रायल कमेंट्स भी हो चुका है, subsequent dates have also been given, और रिकॉर्ड ज्यादा बल्कि नहीं है, 5 to 10 विटनेसेस हैं, इन सच केस यू कैन नॉट कम एंड से कि मतलब मनीष सिसोदिया में भी यही हुआ था, लॉन्ग पीरियड ऑफ इनकार्सरेशन के लिए आपने दे दिया था बेल, तो मुझे भी दे दो. सी, फैक्ट टू फैक्ट बेसिस पे सर्कमस्टांसेस विल आल्सो डिपेंड. ओके, the next act or the next statute we will be covering is the Narcotic Drugs and Psychotropic Substances Act. दिस इज वन ऑफ द एक्ट्स जो कमेंट्स में आपने बताया भी था कि इज अ स्पेशल क्रिमिनल लेजिस्लेशन. करेक्ट, इट इज. ये इंट्रोड्यूस करवाया ही गया था विद द होल ऑब्जेक्टिव कि व्हेन यू, द होल एस्पेक्ट ऑफ नार्कोटिक सब्सटेंसेस एंड ड्रग्स, टू पुट इट इन द मोस्ट सिंपलेस्ट ऑफ टर्म्स, को, to deal with it, to to you know procure it, to sell it, etc. इन सब चीज को curb करने के लिए this whole the whole idea why this act was brought into the place. Now we'll again take a look at the aspect of bail when it comes to NDPS. Now this is again very interesting. So we may recall that when we talked about PMLA, section 45 के बारे में I told you. Section 45 states कि दो conditions fulfill होनी रहती है basis which you can grant somebody bail. Similarly, NDPS में भी there is a provision that states for grant of bail. The first is again the whole aspect of the public prosecutor being given an opportunity to oppose the bail. The next is that the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offense and is not likely to commit any offense while on bail. This again goes back to the whole aspect that we have already dealt with. But now we have to also understand something. देखिए, NDPS are such cases जहाँ पे the honorable courts are not very inclined in granting an accused bail. Can anybody tell me why is that? I mean, this is also a special criminal legislation. फिर इन केसेस में एनडीपीएस के केसेस में व्हाई विल द कोर्ट बी मोर stringent in say denying somebody's bail? Your answers again in the chat box, guys. I am going through them, so I'll be able to see them. Feedback form. Right, so I can see two responses. One is from Purnima which says, sir, narcotics youth को बहुत ज़्यादा इफेक्ट करता है. ठीक है, it's a valid point. Next is from Harman which says, due to the vast network the accused might have. So more or less, in a way, I could agree to that point. Again, Gamini says vast network because of health. Somebody says so. Okay, ठीक है. In a way, you're all correct. The whole aspect is up. You understand something, right? Key. The whole offense under NDPS is of such a nature that it not only affects individuals, राइट? आप देखिए, आप एक क्राइम करते हैं अगेंस्ट एन इंडिविजुअल, यू आर अफेक्टिंग देम. आप कुछ करते हैं, यू आर अफेक्टिंग एन इंडिविजुअल और यू आर अफेक्टिंग अ सर्टेन ग्रुप ऑफ पीपल, विच ऑब्वियसली इज ऑल्सो अ क्राइम नॉनदलेस. लेकिन आप एक बात समझिए, when you are somebody that is full-fledged running a narcotic network in your country, or you are somebody that constantly supplies narcotic substances, it is something that spreads like wildfire. ऐसा नहीं रहता कि आप एक दो लोगों पे रिस्ट्रिक्ट हो जाते हैं. It is like a constant chain, that keeps reaching one person to the other, one person to the other, one to the next. And which is why, again, like the Honorable Supreme Court had also very particularly observed, or in Union of India versus Ram Savuj and another, the case that is there in your screens, is one such case in which the Honorable Supreme Court had very categorically made this very particular. And I think this is one of the case laws that has actually helped, conviction, or to avoid or to prevent, very easily individuals being alleged offenders under the NDPS Act from being granted bail. So, isme the Honorable Supreme Court said in very simple words that NDPS offenses under the NDPS Act is not very simple like that of murder. It affects the entire country at large. Very particularly, like a lot of you also mentioned, affects the youth and goes against the integrity and sovereignty of the country. Which is why, when considering or when persons that are accused under the NDPS Act, they should not be released on bail during trial unless the mandatory conditions under Section 37 is fulfilled. See, what this judgment has done in essence is that it has basically stated that you may have your Article 21, nobody denies that, but सेक्शन 37 जब आपने एनडीपीएस के ऑफेंसेस के अंडर के ऑफेंसेस कर दिए एंड यू आर अलेज्ड टू बी समबडी that is said to have committed offenses under the NDPS Act. You cannot very simply state that, I have been in the custody for a long time. I'm not somebody that has done a grave offense. If you are somebody that had orchestrated the entire chain of offenses, it is very less likely that you get bail when it comes to NDPS. Now, again, Section 37 में what it said, what the provision read was that the honorable courts must be satisfied कि एक reasonable ground exist करता है. अब हमने पीएमएलए में भी ये चीज डिस्कस की थी कि व्हाट आर रीजनेबल ग्राउंड्स. हमने रीजनेबल ग्राउंड समझा था कि क्यों रीजनेबल ग्राउंड्स होते हैं एंड व्हाई इज इट नॉट अपॉन अपॉन कंप्लीट सेटिस्फैक्शन, राइट? नाउ लेट्स टेक अ लुक एट व्हाट डू द ऑनरेबल कोर्ट्स मीन व्हेन दे यूज द टर्म रीजनेबल ग्राउंड्स. The whole aspect of reasonable grounds was defined by the Honorable Supreme Court in State of Kerala versus Rajesh, which says reasonable grounds mean something more than prima facie grounds. It contemplates substantial probable cause for believing that the accused is not guilty of the alleged offense. The reasonable belief contemplated in the provision requires existence of such facts and circumstances as are sufficient to themselves to justify satisfaction that the accused is not guilty of the alleged offense. Abhishek, what can we understand in essence? In essence, while we consider the term reasonable grounds, it does not mean कि आपने argue किया, आपने कहा कि इस दिन तो मैं यहाँ था, उस दिन मैं यहाँ था, मैंने ऑफेंस कैसे किया, नहीं. The material that is on record, the in if in a predicate offense you have been named and you are there in the FIR, or if upon the investigation having been taken over by the NDPS and upon their complaint being filed or on the report that they have prepared, if they are able to show somehow that this is how you are involved on this date, so and so happened, this is the huge quantum of narcotic drugs that are involved in such an offense, how they apprehend that you may be involved. So these are all reasonable grounds that they take into consideration. To understand, the honorable courts will always ensure that they take all these factors into consideration before they grant an individual bail. This is again another simple case of Supreme Court. इसमें हुआ क्या था? There was the magnitude of drugs that were apparently seized were of a very very high quantity. And when I say very high quantity, you understand कि for any particular drug or substance to be under the category of a commercial quantity as per the NDPS, a few grams are required. ऐसा नहीं है कि आपको kilograms में होना चाहिए तभी commercial quantity है, नहीं. Very minute amount, anything beyond that is a commercial quantity. In this case, what happened was there was a very very high magnitude of a particular narcotic drug, which I would not want to really use a term in. But yes, what sometimes people call is weed is something that was seized, and it was in a very very Goliath quantity of somewhere around some tons. Is case mein what happened is the applicant had approached the Honorable Supreme Court stating that he seeks bail. He's been incarcerated for a long period of time. However, while the Honorable Supreme Court did consider the uh, whole ambit of Section 37, it also very particularly observed that the seized quantity of drugs were very high in nature, were of a very high number, so therefore bail is not something that can be ordinarily granted to them. Next. Now, we come to the bail under the Terrorist and Disruptive Activities Prevention Act of 1987. Does anybody know about the TADA or anything about the act as to what? I mean, my slide says that it is now repealed, but can anybody tell me why has it been repealed, or what was the whole genesis behind it coming into place? I'll wait for your comments in the comment section in the meanwhile. Isha says to prevent terrorism. I mean, yes, that's the whole aspect of why TADA was introduced. My follow-up question would be, can anybody tell me why is it repealed? Ananya says repealed because of misuse of power. Okay. So, okay, if I am to very summarily tell you why it was repealed, I mean, I would not want to spend much time in this act because it's now repealed in any case. See, the whole idea behind TADA was to curb with terrorism that had become very prevalent in the country around the late 80s, 1980s, right? So this act was brought into place. It also, again, like the other two acts that we mentioned, had similar bail conditions, twin conditions being, which are in any case, see, what you'll notice is that they are very identical in nature, more or less, all of them, right? Now, this act was repealed for a very simple factum that it did not hold much accountability. When I say did not hold much accountability, what I mean is कि आप अभी कंसर्न पुलिस ऑफिसर को जो भी स्टेटमेंट देते वो कोर्ट में एडमिसिबल हो जाता था. You were not required to be presented before the learned magistrate or the concerned magistrate within 24 hours of your arrest. And there had been instances where people that were arrested were kept in police custody for almost approximately around 60 days and not brought before the magistrate. More than that, there were not really conviction rates. बहुत सारे reasons थे. टाडा repeal हो गया. अब टाडा तो repeal हो गया. Now the question that we may have is then what happens to all those activities that are, terrorist activities in nature, या फिर they pertain to anti national activities. See, there was already a law in place for that matter. There was a law by the name of UAPA, Unlawful Activities Prevention Act 1967. Now you may have a doubt as to अगर सर ये act already था, then what was the purpose of TADA? See, UAPA was introduced back in 1967, right? And back then, UAPA is not very restricted to one aspect of any unlawful activity. It is a umbrella terminology जिसके अंदर बहुत सारे acts, बहुत सारे offenses आ जाते हैं. Pankaj has also a question that says, "What is the POTA Act?" See, that was also a similar act to that of TADA. It came into place once TADA was repealed. It also had a sunset clause. A sunset clause meaning कि कभी भी एक एक्ट अगर आता है और उसका पर्पस बहुत रेस्ट्रिक्टिव इन नेचर रहता है एंड इट इज टू ओनली कर्ब विथ very specific offense that has been committed in a very specific period of time. So this also had a sunset clause in any way. It is similar to the Torts Act that came at the time when the Harshal Mehta scam had happened, and to deal with the whole offenses pertaining to the securities market, right? That act was also, I believe, in place between 92 to 1994. Similarly, these acts were also there. I mean, TADA and was extended from time to time on the basis of ordinances. Like it was, in essence, both these acts were very ineffective and they did not really serve a fruitful purpose, which is why they are now repealed also. So, coming back to UAPA and how anti-terrorism or anti-terrorist activities were now dealt with by the UAPA. So you see, UAPA being in 1967 did not cover the ambit of terrorist activities. When was that introduced? It came only upon the amendment that came in 2004, after which the preamble of the act as well as the offenses that fall under UAPA, usme terrorist activities were also included. So henceforth, since 2004 up until now, all activities that pertain to terrorism or terrorist activities per se are covered under the UAPA Act. Uh, I believe somebody has given a comment as to why TADA was repealed. Stringent provisions like long detention periods without trial raised human rights concerns. Absolutely, 100% you're correct. Okay, so now we come back to the aspect of bail conditions, right? Now you see something, you will realize a slight shift, per se, if you were to see from the two or three acts that we've already dealt with. Here, in such a case, the only satisfaction or the only factor that they have restricted here is for the honorable courts to consider whether there are reasonable grounds for believing that the accusation against such a person is prima facie true. Next. See, I'll tell you what we notice from here is that while on other statutes very specifically provided that and also satisfied, there were two conditions if you can recall. One being that prima facie satisfaction hai ki haan isne kiya hai offense. Second being that even if he has done the offense or even if he has not done the offense, if enlarged on bail, he will not commit the same offense again. We see a slight shift when it comes to offenses under the UAPA. The only satisfaction then that there is required is at the moment that the honorable courts feel ki yes, this particular individual has committed an offense that is punishable under the UAPA, and the courts are satisfied prima facie that there is a case against him. That is enough for them to not grant somebody bail. Again, this case is the most significant or the most landmark case when it comes to dealing with the whole aspect of Section 43D of the UAPA Act, that is the NIA versus Zahur Ahmad Shah. Now, in this case as well, right, the Honorable Supreme Court very categorically held that whatever the reasonable grounds are there that exist, it should be sufficient for the Honorable Courts to form an opinion that yes, prima facie, there are reasonable grounds for believing that the accusation that has been made against this particular individual is is prima facie existing. So therefore, he or she should not be remanded on bail. See, offenses that are again under the UAPA are of such a nature that you understand something. अब इस पर्सपेक्टिव से सोचिए, आप सुप्रीम कोर्ट हाई कोर्ट में जज बैठे हो, आपके पास एक बेल एप्लीकेशन आता है जिसमें द अक्यूज्ड इज अ प्राइम अक्यूज्ड इन गॉड फॉरबिड एनीथिंग लाइक दिस एवर हैपेंस इन आवर कंट्री, बट मान लीजिए कि यू आर समबडी दैट इज एन अक्यूज्ड इन अ bomb blast that took place in a particular place, right? उसमें a lot of people lost their lives, a lot of people were injured. Now you come to the court seeking bail. You don't, I mean, somebody approaches you in your court and states, ki, my lords, I should be granted bail. Why? Because XYZ reasons. You understand the ramifications of what it, I mean, even for the honorable courts, right? They also take a lot of aspects into consideration when deciding whether to grant bail or not. And specifically, if you take into consideration the grave nature of offenses जो यूएपीए के अंदर आते हैं, तो आप भी नेचुरली बहुत इंक्लाइंड नहीं रहेंगे इन केसेस में किसी एक यूएपीए ऑफेंस के अक्यूज को बेल ग्रांट करने के लिए. सो दैट इन एसेंस इज व्हाट यूएपीए कवर्स. So one of the last specific, this is not particularly an specific legislation per se that governs criminal legislation, criminal offenses regarding bail, but the Companies Act also has a provision wherein it grants powers to the Serious Fraud Investigating Office, or that is in short the SFIO, which is a special investigating agency जिनका काम और जिनका पर्पस ही रहता है उन कॉर्पोरेट और इकोनॉमिक ऑफेंसेस के ऊपर इन्वेस्टिगेशन करना that have taken place, right? Similarly, the in offenses where the SFIO has taken cognizance of any particular alleged offense having taken place, उसमें भी there are similarly dual twin conditions that need to be fulfilled. And these are against economic offenses जिनका, I mean, see, these are corporate offenses to be specific. So it is for the SFIO or the prosecution when they are trying to get any bail so being pleaded in such cases dismissed or not been granted. वो ये claim करते हैं the amount of money that is involved, the quantum of money, कितने crores में है, बहुत grave nature का economic offense है, etc. So in such cases also what the honorable courts do is they again weigh the perfect balance between what the has the investigation commenced, has the investigation concluded, if the investigation has concluded, has the trial commenced, if not, why is the reason why it's not concluded, and even if the trial has commenced किस stage में है, अगर किसी advanced stage में नहीं रहता है 4 साल पहले से ट्रायल कमेंस हो चुका है लेकिन आप बहुत प्रिलिमिनरी स्टेज में हो, तो इन केसेस में इट्स वेरी ऑर्डिनरी, आई मीन इट्स वेरी common that the honorable courts will be inclined to granting bail to the accused. अब this is the last aspect of our lecture, bail in other state specific legislations. So can I get a few response? I mean, see, it's more or less there in the background of this particular slide itself. But can anybody tell me what are state specific criminal legislations and उनका purpose क्या रहता है? In essence, in very layman terms, if anybody could explain to me. I will wait for your responses for a couple of minutes. Okay, let's go. So, see, there are two aspects that we will majorly be looking at when we talk about state-specific criminal legislations. Okay, the first being the Maharashtra Control of Organized Crime Act of 1999, uh, also in short called the Makoka Act. This, in essence, had been brought in place to deal with the very specific criminal activities or the organized crime, to be in particular. I mean, I think there has also been, it's not something that is not unknown to all of us, right? I mean, there are a lot of aspects that has burdened the country when it comes to criminal activities that took place in Mumbai or in Maharashtra, and a lot of infamous criminals or gangsters, so called, that we know of or we hear of. So, yes, similarly, Makoka was one such act as well. Uh, I think now I'm beginning to see the responses. Uh, Dharna says it refers to laws enacted by individual state legislations rather than federal or central government. Absolutely. Purnima also says the same, is that are made specific states. So, all right, yeah. So, all of you have, in essence, the idea of what these particular acts govern, right? Again, similarly, Makoka under Section 21 has the whole more or less the same aspect. The same is again governed by the Makoka Act. In the Honorable Supreme Court has in adjudicating upon a case that is there in front of his screen, you can see, has very particularly stated that a mechanical application of mind cannot be done when granting bail, right? Each and every case must be considered on its own facts, and it's not necessary that just because somebody is agree, if the honorable courts are say agreeing or are or are forming an opinion as to whether or not a particular individual should be granted bail, it is not to say that they have formed an opinion that yes, this individual is not guilty. So there was this distinction that was made. Now, the problem that often arises with very state specific legislations is a conflict with regard to its application. We sometimes may not know, I mean, there may sometimes be some sort of a discrepancy when it comes to what are the state specific legislations that are to be abided by or the central legislation. The next, similarly to that of Makoka, there is another legislation in the name of UP Gangsters and Antisocial Activities Prevention Act. Similar to that of what I already mentioned, Section 19.4 deals with the aspect of dual conditions that are to be met. This is currently under challenge before the Honorable Supreme Court. The main genesis of challenge being that the whole objective of this act is more or less covered under Section 111 of the BNSS, and therefore there is a conflict between a central and a state legislation, and therefore the same should be repealed. That matter is sub judice as of now. As and when it is determined, I think we'll all get to know what the eventual fate of the matter is. Now is the last aspect of our lecture before we conclude. It is about successive bail applications. I would have waited to hear from you people with regard to what you feel is the meaning of successive bail applications, but I think we have really exceeded our time, so I will not take much time and very briefly just explain what this term basically means is you understand something, right? You are an individual that has approached the honorable courts. आप कहते हो कि आपको बेल मिलना चाहिए, आप एक्स वाई जी रीजंस देते हो कि आपको बेल मिलना चाहिए, वो बेल आपको नहीं मिलती है। अब ऑब्वियसली नहीं बैठे रहेंगे, आपको आपको लगेगा कि नहीं मैं फिर से अप्रोच कर सकता हूँ कोर्ट को। तो मान लीजिए आपने कोर्ट को अप्रोच किया था 2023 में जब इन्वेस्टिगेशन चल रहा था, एंड बैक देन इट वाज argued by the prosecution's case that no, you cannot be granted, you should not be granted bail। क्यों? क्योंकि आपने बहुत हीनियस क्राइम किया है और क्योंकि आपके अगेंस्ट बहुत स्ट्रॉन्ग एलिगेशंस है और इन्वेस्टिगेशन में आप यू आर रिक्वायर्ड टू बी रिमांडेड इन जुडिशियल कस्टडी। ठीक है। इस आर्गुमेंट को सुन के कोर्ट्स जो हैं आपको 2023 में मना कर देते हैं बेल ग्रांट करने से। अब आपको वापस लगे कि यू कैन अप्रोच द कोर्ट अगेन। सो सी, you can approach them, right? It is in essence your right to seek a successive or a second bail application. But in such cases, you need to ensure that there is a very important aspect or a very important term that we often associate with the whole factor of a successive bail application. It is the terminology called change in circumstance. A change in circumstance, in essence, means what? Ki, say you approached a court in July of 2023 stating XYZ reasons. This is the stage of the investigation. This is the stage of the, this is the stage of the investigation. This is my role. Trial is yet to commence. Hence, I require bail. Now, you cannot subsequently come and approach the court under the same points, stating after say 1 month या फिर 2 महीने बाद आप आके ही नहीं बोल सकते हो कि नहीं, अभी भी इन्वेस्टिगेशन इज स्टिल ऑनगोइंग, दिस इज माय रोल, ट्रायल इज नॉट कमेंस्ड, therefore I want bail. That in essence would mean that you are trying to review the order of the particular court. You cannot do that. Change in circumstance hona is an absolute mandate without which you cannot seek a successive bail application. And in such cases what happens is that, as if I were to give you an example of change in circumstance, it would mean, if I'm to again take my first example, you approach the court in July of 23, you state that investigation is ongoing, trial is yet to commence. Now you approach the court in Feb of 2026 stating that, my lords, the investigation has concluded, the trial has commenced, I have cooperated at the time of investigation, there is nothing that warrants my being in judicial custody still, so therefore I seek bail. This is a change in circumstance. Or you say that when you first sought bail, trial अभी start हुआ था, अभी आपने जब approach किया तो trial has reached its concluding stage. So therefore, then you show this as a change in circumstance, and then maybe your bail will be accepted. The case laws that I have in front of you more or less deal with the same aspect. That being said, I am done with my part of the lecture. If I was to very summarily in 30 seconds or so conclude whatever we've learned today, it is that bail is often pleaded to be a matter of right, but when it comes to aspects of specific criminal legislations where the offense is of such a grave nature that it is not really something that can be deemed to be a matter of a right, it is to be weighed with the strict rigors that these specific legislations provide for. In all cases, bail will be dealt with from a case to case basis, wherein a lot of conditions are to be imposed by the courts. A lot of factors are taken into consideration before granting or denying you bail. And in essence, if I was to put it in one statement, it would very simply mean that bail, when considering an application for bail, the honorable courts will always try to strike a correct balance between the your right provided to you under Article 21 of the Constitution of India and the strict rigors that the specific legislations otherwise warrant. On that note, I thank you all for your patience. I thank you for your time. I would be open to questions if we have any.
Thank you, sir, for showing your valuable insights with us. Now, I invite all participants to engage in the question and answer round, where you are free to ask questions to Priyanshu, sir. Sir, we have first question is what will happen in cases where the court granting bail for offences under the PMLA or UAPA etc. doesn't specify the grounds for granting bail?
Uh, okay. So see, one aspect I think that we've dealt with is that when you read the provisions, right, it very specifically states that there are reasonable grounds to believing. Now, why it becomes important for these courts, for the honorable courts to, mention the grounds why they believe or what is the prima facie satisfaction that they have done, is because see, eventually, no matter what order is granted, right, people, an accused that is there in judicial custody would want to seek and would want to assail that order via an appeal. So in such cases, what ordinarily happens is that they often use this. It's a very minor loophole, or it's not necessarily also a loophole, but it is one very hyper technical thing that people will, or an accused will use. They will state that they will not simply state that the reasons are not there. What they will try to do is that they will state that section 45, if I am to very specifically just mention about PMLA, right, they will say that the twin conditions of section 45 are not met. The reason being that the honorable court has considered the matter, but it has not satisfied itself. And even if satisfied, what are those things that it has satisfied itself against? So, which is why, I mean, it becomes, in such cases, what happens is that the order then becomes susceptible to special leave petition or an appeal before the Honorable Supreme Court or the High Court, as the case may be. So, which is why, I mean, having proper grounds recorded by the Honorable Courts becomes very important.
Thank you, sir. Next question is will Article 21 not overlap or supersede the statutory provisions?
Right. Okay. So I think this is something that I had also covered towards the end of my lecture. See, it will, it should. I mean, in all ideal cases, if you look at it, right, it is a fundamental right that is enshrined to every individual as per the constitution of the country. However, like I mentioned, these are factors that will not be kept in abeyance. This is something that will always stay in the. It is one. It's like you look at a weighing machine, right? There are two parts of it. Article 21 is the one part of it. It will always be there, and that is something that exists. What the honorable courts then try to do is that whatever are the other conditions that they are imposing, a balance needs to be made. So one cannot weigh over the other in any manner. So yes, obviously Article 21 does, which is why on a lot of grounds we see that people having claimed that that their Article 21 is being violated under say specific offenses like PMLA, they go and seek bail and then they are granted that they are in custody for the past 4 years, 5 years, etc. So yes, it will weigh down.
Thank you, sir. Next question is what happens if two accused persons have the same role and the same offense under the special legislation and one of the accused has been granted bail?
See, what will happen is in such cases, the other person will also have to first approach the court for bail. It is not something that is automatic, obviously. You approach the court stating, I mean, very well highlighting why or how you are seeking bail. One of the major grounds then becomes is that you have similar roles. It becomes the case of the prosecution to try and show how that person's case is not at all similar to that, or how your offense is much more graver than the person that has already been granted bail. So there will always be an attempt to distinguish both the roles. In case both the roles are not distinguishable and both the roles are absolutely similar, which is not really the case in most of the times, but if it is, then yes, that person will be entitled to bail.
Thank you, sir. In closing, we extend our heartfelt gratitude to Priyanshu, sir, for accepting our invitation and delivering such an informative session. We trust that the audience found it both interesting and knowledgeable. Thank you once again, sir, and we eagerly anticipate the opportunity to host you again.
Thank you so much, Just Corpus. Again, we're grateful for this, and I can only say that keep up with the good work.